Ormson Law Training would like to welcome you to today's presentation, Writing Winning SSD Briefs from an OHO Adjudicator. Our speaker today is Terri M. David. Terri is a Social Security disability representative and brief writer. She worked with OHO for 13 years as a senior attorney adjudicator and ALJ decision writer. As a former middle and high school teacher, as well as an OHO national trainer, she continues to consult and teach SSD professionals on how to win more cases through advocacy and persuasive writing. If you're interested in Terri's products and services, please visit her website at terrimdavid.com, and you can also email her at terri@terrimdavid.com. We will email you this information after the presentation. With that, please welcome Terri David.
Okay. All right. Well, welcome everyone. And I look forward to diving into writing briefs. Not only writing briefs, but writing them persuasively and winning more of your cases. First, I would like to start out by thanking Craig for this amazing opportunity to not only improve our individual skills, but also improve the integrity of the industry. So thanks, Craig. Appreciate it. Okay. So as Craig mentioned, I began my Social Security career as a decision writer in Nashville, Tennessee in 2004. And then moved on to Falls Church in 2006. That's when OHO became ODAR, and now it's OHO. I ended my Social Security career in Houston as a senior attorney adjudicator, and one of the highlights was training new writers, new attorneys, mentoring. That was so much fun. I love that. I'm a former teacher, so that just falls right into my skill set. So in 2017, my family and I had the opportunity to move abroad for my husband's job. So I actually get to do most of my work from Morocco. I'm currently in Wisconsin, so I travel back and forth. But you know what a great opportunity for me and my family, and also staying connected to the Social Security disability community. I feel really grateful and fortunate for that. So my why, moving on. So when I left the agency, I, reevaluated, what I want to do with this experience. And I decided that I really wanted to support our industry, our community, but in particular, representatives. Just being an adjudicator, I felt like there was something that I could contribute. And so now I do consulting, coaching, do a lot of brief writing. That's what I primarily do. And create training products and train when I can. So that's kind of my why, but also why am I doing this webinar is so that I can get to know you all a little bit better and you can get to know me as well. All right, so what are our goals? Well, we're going to go over brief writing tips for sure, and reviewing the file efficiently. I find that that's important to not only finding the right information, but also we all work in a production-paced environment, so knowing where to go to find this information is important. I'm also going to go over how to draft our briefs persuasively, not just summarizing the evidence. And personally, I got to a point in brief writing that just summarizing the evidence was really boring. So I found that when I started writing more persuasively, it was not only a better product, but also more interesting. I'm also going to go over some exceptions and forewarnings of the 5 sequential step evaluation, just to give you a heads up on some things that I've learned along the way. So as you see, there's a poll, and we have a couple of polls so I can get an idea. For example, the first one's, how many briefs have you written? I know some of us have other people writing our briefs. We write our own briefs, or a combination. So yeah, just let us know what your experience is. And so 50 and plus, cool. We have some brief writers. I love it. Hey, I know what that is like. I cannot imagine how many briefs I've written over my career in the agency as well. I mean, wow. The last I checked before I left, 40 briefs a month, or it was kind of expected as 100% production pace. Oh, yay. All right. All right. And moving on to types of briefs. So there are many types. In a second poll, I'm going to get an idea of what you typically write. Now, we're limited in time, so I'm going to primarily cover on the records, pre-hearing, post-hearing briefs, and at the end, I'm going to touch on appeals counsel briefs, court briefs, primarily dealing with post-hearing issues, VE testimony, and remand. So we have some experienced writers, and I'm glad that I've decided to focus on the record pre-hearing and those immediate post-hearing appeals counsel briefs. All right, so we'll go over all that, have a good idea of the audience. Moving on, before we even dive into substance, I wanted to cover preparing to write. This is easy to skip over, but I find it sets me up for success. And what that looks like. Okay, we're going to be writing when we sit down to write for an extended period of time. So I go ahead, I get my snacks, I get my caffeine, I get, restroom break, and I get kids settled if that's the situation. My dog outside, back in, and start clearing that mental clutter. If you have social media, I go ahead and check that. I check my emails before I even write. If a phone is a distraction for you, which it is for me, I put it on vibrate, or I move it away so that I don't easily grab it for distraction. And on the days that I'm having a particularly difficult time focusing, I also set a timer for an hour or two, and I just commit to writing and focusing on my task at hand for that period of time. So otherwise, I can be kind of scattered and be easily distracted, either with social media, my phone, or even just getting more coffee. The last thing is getting clarity on instructions. Before I even sit down to write, I need to make sure that I understand either what the case is asking for or my client. If I'm writing for someone else, I need to be clear on the type of brief and any specifications they have, if they have any preferences, any notes associated with that case, then I want to get clarity on that before I even start writing. That typically helps me get through, create a better product. All right, so in my experience, I pretty much see the brief is there's a beginning, middle, and end. So I'm going to start with the beginning. And I'm going to indicate different parts of the file to officially find evidence. And I just want to note that I understand that most people don't have access to the file until the OHO level. Know that you can request a CD in the very beginning, and I highly recommend that. And it doesn't take long. It's part of the process. It's easy. They just burn a CD, mail it, and then you have access to what's in the record, at least, at that time. All right, so the beginning of the brief, every brief, there's a heading, and that will include, the ALJ name, location, hearing. I efficiently find that evidence in section B in the hearing notice. And I make sure that I'm looking at the most updated hearing notice. You make sure if there's been a rescheduled hearing, make sure you're looking at the most recent one. You will have, everything you need for that, the heading, the location, date and time of hearing. And essentially what you're doing is you're not only familiarizing yourself with the case, but also the judge. They work in a production-paced environment as well. So start guiding them in the process. This is a collaborative effort. And so you're going to pitch who, the claimant's name, social security number, where the hearing is. If it's a video hearing, you'll indicate that. When, date and time. And, if it's a video hearing, indicate that. So that's your heading. You can also find some of this information in section A in the disability determination exclamation called the DDE. That's a great information as well. So we're working on essentially just guiding the ALJ with the heading. And then we move into introductory paragraphs at the beginning of the brief. And here we start what I call creating a profile for the judge. And that's because every adjudicator, before they even really dive into a case, they are thinking, okay, what age is this claimant? What is the education? What's the past relevant work? So they are creating this profile. You can help guide them by putting this information in the introductory paragraphs. And again, you can find this information also in section A in the DDE. It's great. On the first page of the DDE, you have the alleged onset date, you have the claimant's age, you have birth date, you have DLI information. It's a great quick grab. And regarding the DLI, you can also go to section B in the certified hearing report, and that's where you'll get the most updated DLI. And then also you can go to section E to get more information, for example, on past relevant work. There, some claimants will complete the work background or work activity forms, and you can start assessing the past relevant work. And if there's going to be any past relevant work issues at that point, again, you're helping create this profile for the ALJ, for the AAJ or judge, depending on the type of brief that you're writing for. But continue to guide them through that process for you and the judge. Moreover, in the introductory paragraphs, there's also getting clarity on if there are any issues, you're identifying problems. And again, sections A and D are great go-to quick checks for this. So for example, in the DDE in section A, if BMI might be an issue, it's on the first page. I've had both in the last couple of months, I've both had obesity, a BMI of 30 and over, but also really low BMIs. And they're often looked over, but watch for those. Also in the DDE in section A, if there's DAA issues, they are sometimes mentioned there. Again, DLI issues, and check in section B in the certified earnings to identify any DLI issues. In section A in the DDE, you're also going to get clarity on what type of claim this is. Is it just Title II only, Title 16, concurrent? I did one last couple of days that was a widow's benefit. So get clarity for yourself, and if you're writing for a client, them as well, the ALJ, what type of claims you're dealing with. And again, you can get that quickly in sections A and D. Now, identifying problems, I've mentioned the DLI, especially if you're dealing with a Title II claim, you need to get clarity on DLI so that if it's a remote DLI, you're going to focus on evidence at that point rather than currently. So let's say the DLI is 5 years from now. Well, you're going to focus your efforts at that time period rather than just focusing on current issues. And also, other possible issues could be SGA, and you'll identify that at the beginning of the brief. And my go-to on that is also Section D, the Certified Earnings Report, but also the DDS level determinations will also indicate if there's possible SGA. But you'll identify that at the beginning of the brief. Again, if there's substance abuse, particularly in mental only cases or a recent substance issue, then you'll want to go ahead and get clarity for yourself that you're going to have to deal with that. Again, that's often mentioned in DDE in Section A. All right, so moving on. Let's talk about some exceptions and forewarnings to step 1 and step 4. All right, so there are so many exceptions to step 1. If you have a client, if your client has SGA, if you're writing for someone that has SGA issues, look for those exceptions. There are so many to get you past that step 1. You have to get through step 1. So some common exceptions that I saw that are not considered SGA are sick and vacation leave that are posted after the alleged onset date. Those are not counted as countable earnings or SGA. And essentially just get that evidence from either the claimant or HR department and submit that to the evidence. Other exceptions, short and long-term disability that is posted maybe in the W-2 but definitely in the earnings reports that are in the file. Same thing, just get that information, submit it in the evidence so that the judge knows that there's earnings after AOD, but it's not SGA. And then it's an interesting one that comes up that I've had interesting conversations about are unemployment benefits. So SSA policy is that judges cannot use a claimant receiving unemployment benefits against them. They have to look at all the evidence as a whole. Now, some judges have an issue with claimants who receive unemployment benefits, and they're going to mention it whether they pay or deny it. But just know that they cannot deny a claim based on that alone. Even though Judge ALJ Cristado put out a memo, there are some judges that still just have a real problem with that, particularly in states where the claimant is signing documents that they are ready and willing to work. Know that you can get around it, but you'll need to address it. And some of you probably know your ALJs and know which ones have a problem with it and which ones do not. Also, unsuccessful work attempts are a great way to get around SGA. So if there's at least a 30-day break between the time the claimant stopped working and they went back to work, and it was at SGA level, then if they worked less than 6 months and they stopped due to their impairments, then you can get past step 1. That's an unsuccessful work attempt. So keep that in mind. All right, so past relevant work exceptions and forewarnings. For past relevant work to actually count, it needs to have been performed in the last 15 years, performed long enough to learn the skill level between unskilled, semi-skilled, and skilled, and it has to be at the SGA level. If it does not meet those 3 things, then it's not past relevant work. And I just wrote one today where DDS said that the claimant had past relevant work, but when I looked, it wasn't at the SGA level. So it's not past relevant work. So keep those in mind. Use them when you need them. Again, if you see SGA, then there are many exceptions out there. And I don't have time to go into each and every one, but there are a lot getting past step 1. All right, so I just wanted to show a couple of examples of what we've gone over so far. So here is an example of a heading that I typically put together. You have the judge's name, location, and the claimant with name, social security number. And then moving into the introductory paragraphs, just show you a couple of examples. So for example, the first paragraph can be called either introduction or procedural history. And here, this is where you're putting which type of claims are at issue, when they were filed, when the claimant's alleging disability, if there are any prior files. It's good to note that because if there are prior files and it falls within a reopening criteria, then you just made yourself and maybe your client and the claimant more money if you can get it reopened. And so there's your typical procedural history. And then moving on, vocational factors. I separate the procedural and vocational. You can put it all together. This is just my preference. Here I indicate the claimant's age, education, if they can communicate in English, and past relevant work. And I include the DOT number. This is easy. Google, dictionary of occupational titles. and you have everything you need, the number, the exertional, and skill level. And I wanted to mention step 1 can actually go in the beginning or middle of the brief. It kind of depends on the case. If there's not a big issue, I might go ahead and include it in the middle, but it's not that big of a deal. I just wanted to clarify that it could go either, because it's kind of in that transition where we're moving into the middle of the paragraph. But here I mentioned any SGA. I used this as an example. There was sick and vacation payments, and I let the judge know that they're not countable earnings nor SGA. All right. So, questions. And while Craig is pulling up some questions, I'm going to go over a couple things. So I showed you some examples, but if you want more samples of writing, at least my writing, on my website shop, for each of the different types of briefs, I provide a sample, I think for most of them. And it's just a click option. You can take a look at that. And also, because I can't get everything in an hour, I did want to let you know I've created a brief writing product that is an hour-long video and a 9-page PDF. If you're interested, I provided a discount throughout until the end of August. And it's winning, WINNING. So if you are writing briefs and you want that, you get 15% off for a little over a month. And also, if you don't want to write briefs, I write briefs and I have a sale going on, and you can check that out on my shop as well. All right. So we have any questions?
So here's our first question. Are citations really necessary while writing a brief?
Well, it is helpful in specific issues. For example, we have a new SSR for obesity, 19-2P. And so I would definitely include that regulation. You don't necessarily need to cite case law at the OHO level, but in maybe appeals council briefs or court briefs, you would mention more regulations at that point. But for ALJ level and below, the citations you would include or the exhibit, page number, applicable Social Security rulings, and maybe ARs. Are there any other questions?
Yes. What is your technique in reviewing and taking notes regarding the medical record before outlining?
Oh, that's a great question. What I do now and what I did as an adjudicator, and I think most adjudicators do, and that is starting in section A with the DDE. There you have all your basic information such as claimant's name, social security number, age, date of birth, AOD, sometimes even if there are DAA issues, DLI issues. BMI is stated on the first page of the DDE. So that's the first place I start. I start creating the profile. I get direction and clarity on possible problems. Looking at the DDE, you find what DDS found are severe impairments, which listings were referenced, what's the RFC, and the vocational specialist findings on past relevant work. So starting with the DDE is the most efficient way that I start reviewing the file. and get all the basic information up front first.
Great. Here's one. We'll do one more question here, and it's kind of a follow-up to that, the earlier question on citations. And specifically, I know you mentioned one of the recent SSRs. Is citing regulations necessary, and how often do you cite regulations in the brief?
Okay, so citing regulations, it depends on the case. I mean, if you're doing a short on the record focused on a listing impairment, then regulations probably will not be that relevant. But if you're writing an appeals council brief or a district court brief, then citing regulations throughout the brief will be important and more useful at that level. But at the ALJ level, just deal with agency, SSRs, ARs, and maybe in the beginning and in the middle, and then most of your regulations are covered. At this point, at step 2, you have the new SSR, and at 3.5, when dealing with medical opinions, you have the new 17-2P. Other than that, I would say most briefs, that's about it, not a whole lot. Okay, all right, moving into the middle of the brief. This is a 5-step sequential evaluation. As I mentioned, step 1 is kind of that transition, so included in the beginning, middle, doesn't matter. And then we address step 2, severe impairment, step 3, listings. 3.5, the agency refers to it as step 3.5, the residual functional capacity. And I know some practitioners do as well. And then step 4 and 5. So this is where we dive into supporting the severe impairment, because ultimately that's going to create the RFC. So how do we do this? This is real. I see the whole thing as a collaborative effort with judges, but at this point, even more so, because this is where I'm really building my case. So when I am getting focused on that, the meat of the evidence, I think, how can I help this judge see what I see? How can I persuade the ALJ to see what I see? And how can I possibly educate in the process? I mean, hey, we're all lifelong learners. I'm still learning. I've been doing this for over 14 years. And we have new judges, we have new regulations. So I really see this as a way to work together. It is a non-adversarial process, and I continue to operate as though it is. Okay. Format of the middle of the brief. Here we'll get into the medical evidence. A little different than the beginning. Like I said, I use section A, the DDE, to look at what severe impairments were found, the RFC. But also if you're doing step 1 in the middle of the brief, you'll use section D. Again, there are detailed earnings, there's summary of earnings, there's a new hire report that they update that right before the hearing. And if the claimant decides to go try work, it shows up in the new hire report. So you might want to look at that. And then the E section, we'll use this quite a bit in the middle of the brief, particularly for impairments such as a learning disability where educational records are relevant. borderline intellectual functioning. If there's a traumatic brain injury, there may be some evidence showing a significant decline after the injury, and those are found in section E. Of course, there's also F, which has, the bulk of the medical evidence. And, we'll use a lot of that. So starting us off, the first section in the middle of the brief is medical evidence and conclusions of law. Now, depending on if I'm writing a quick 2 to 3 page brief or an extensive brief, I may or may not include kind of this boilerplate of rules and regulations. Then kind of take a look at that. And I pulled this pretty much from ALJ briefs, and then add, which rules I think are applicable to this particular case. But that's how I start out: medical evidence, conclusions of law. And then I go into step 2. Step 2, all right. Now, the threshold for being a severe impairment is pretty low. It just is. When you think about it compared to step 3, step 2 is pretty low. But it should not be dismissed because the severe impairments at step 2, they lay the foundation for the RFC. The RFC should mirror the severe impairments. And I'll go into some remand issues on this later. So, keep that in mind. Now, for a practical tip, for me, it depends on the case. I either create this at the beginning or end of the review. Like I did one this afternoon. It was clear that there were 3 impairments. And so I went ahead and put it at the beginning of my review. But if it's one of those cases where it's like they have lots of physical and mental impairments, then I might I kind of can finish up step 2 at the end when I've reviewed all the evidence. But here's an example, typical step 2. Now, you've noticed it really is a preference and option. If you include the exhibit and page number for each severe impairment. What I do is, if I'm writing a short brief where I might focus, let's say it's a listing level brief, and I'm only going to focus on the listing level impairments, then I'll go ahead and include all the physical, but I'm going to include exhibit and page number because I'm not going to go over all of it in the brief. I'm just focusing on that 1 or 2, listing level impairments. Now, if I'm doing an extensive brief where everything is, noted extensively, then I may not list the exhibits at step 2. But it also depends on my client. Sometimes a client wants that. Well, of course, I'm going to include it. So it just depends on your situation and what your client or what you prefer. But that's an example. And all right, so a couple of exceptions and forewarnings at step 2. As I mentioned earlier, we have a new obesity regulation. It's SSR 19-2P, and it became effective in the middle of May of this year. So if you're like me, you have all this autocorrect and auto text for our older SSR, you need to update and include 19-2P. There's not a big significant difference, but look it over and know that that's out there. A forewarning that I have at step 2 that I saw a lot as an adjudicator. You have to be careful if your client agrees to amending the onset date, that the duration requirement at step 2 is still met. Because if you amend the onset date and all of a sudden the evidence indicates that there's not a 12 continuous months, then you're going to be in a bind, because then there's no severe impairment. So just watch for that. All right, now moving on to step 3. Those are bittersweet because they're short, sweet, claimants paid, done, analysis. You don't have to go to step 4 or 5. And just focus on the criteria. What I do for step 3 is I kind of have a 3-part process where I let the ALJ know which listings I think are met or medically equal. I'll get into that. The criteria, and then I apply the evidence to that criteria with exhibit and page number, guiding that ALJ to that listing level conclusion. So the exception at step 3 that I'm sure some of you may be aware of is that if the claimant does not meet the criteria exactly, then the ALJ can now make a medical equivalence finding. And so let's say, for example, the claimant, if there's a duration requirement of, let's say, a year or 2, and it's 18 months, then you can still find a medical equivalence. And you'll find this information in section A and F, DDE, and all the medical evidence, and particularly the medical opinions, because those are what really substantiate a step 3 finding. All right, and then I'll show you an example of a step 3, quick step 3. So you see, based on the evidence available as of the date of this pre-hearing brief, claimant does not have an impairment. But I also keep it open to arguing that there is a listing level if we get more evidence or testimony indicates differently. All right. Okay, step 3.5. The residual functional capacity. This is the crux of the case. This is what will be applied at steps 4 and 5. We get all this evidence from sections A, E, and F, the DDE, and then if there's a mental impairment, section E may be relevant if we need educational records. And then, of course, F for all the medical evidence, progress notes, medical opinions. And that includes consultative examinations in or outside the agency. And we just want to make sure that that RFC reflects severe impairments. All right, medical opinions. Essentially, I have 3 types: treating, examining, non-examining. And the ALJs are looking for supportability, consistency. There are 5 aspects that the adjudicator looks at when determining how this medical opinion is consistent or inconsistent. They look at the relationship, the treating relationship with the claimant and the source. Was this a one-time examination? Was this a treating source that has examined the claimant over years? The one I did one this afternoon that had 2 opinions from treating sources that were consistent with each other. So I emphasized that in the brief that that they were consistent with each other, saying that the claimant's not able to sustain work activity on a regular basis. And the opinions need to be supported by medical evidence of record. And the medical evidence that you really want to hone in on is the objective medical evidence. If it's a back impairment, if there's an MRI, great, use it. There's an X-ray and an MRI, use the MRI. If you're trying to, limit your the pages in the brief. If there's a breathing issue, look for the pulmonary function test. Diabetes, look for blood work. But that objective evidence that really supports that opinion. Okay, so medical opinions, exceptions, and forewarnings. So one thing, a forewarning is that it is really helpful to attach supporting evidence with a medical source statement. Even if it's just a couple of pages, if it, just say it's laboratory work and diabetes, one of the impairment. If there's a psychological evaluation and, the case is focused on mental impairments, it's really helpful if the medical source can attach at least something that supports that opinion, and it helps guide that ALJ. Otherwise, they have to look for it, and maybe they'll find it, maybe they won't. But if you go ahead and include it, then you know that they're more likely to see it. All right. Oh, and remember that if there's a specialist, if the claimant's being followed by a specialist, emphasize that in supporting the medical source. All right, here's an example of one of my medical source opinions. And if you will see in that, I do cite exhibit, page number. I also write in detail what the opinion is and supporting evidence. I might mention at least 2 or 3 pieces of evidence to support it, and then conclude at the end, why I think it's supported and consistent. All right, and that is part of the persuasive writing. All right. So in most cases, there are some problems and concerns. We can almost say all cases. There are very few that don't have some issue, like someone decided to go back to college or take an online course, or start working out and it's inconsistent with their allegations. Do not ignore that. Use language that can actually help your case. For example, however, although, and because. When I write, if I see an issue, DAA, whatever it might be, I go ahead and put that in my brief, and I either use although, however, because in that same sentence, and I come back and use evidence that further supports my conclusion. So for example, here we go. So here's substance abuse. Although claimant has a history of substance abuse, he has been sober for 3 years and continues to experience severe symptoms of depression. So, hey, so what? There's substance abuse. This guy happens to be sober, and that helps my case. So I'm not going to ignore it. I'm going to use it. And next. Okay, so we have a claimant who missed a CE. That's unfortunate. But however, in reviewing the evidence, I realized that she missed it because she was in the hospital. So I'm going to use that information. And unfortunately, claimant had to reschedule his consultative examination because he was in the hospital for renal failure. And again, another example of using however. Claimant experiences some pain relief with oxycodone. So great, there's some relief, but we don't want to stop there. However, medicinal side effects include drowsiness and dizziness that preclude performing activities of daily living. So there are some examples of writing persuasively. It's much more interesting for you, and the judge. All right. Step 4, if there's not any significant issues, just keep moving on. I have a quick example of step 4. It's just a one-liner, uh, the claimant's not able to perform past relevant work. And then we get past step 4 and go into step 5. And this is where the ALJ applies that wonderful RFC that you've created to the grid rules. And essentially, and when we've all seen the tables, it's really clear and simple. You apply the profile you created in the beginning with the RFC, and you see if the claimant meets the criteria. Now, the exception here is that if there's a non-exertional impairment in the RFC, you're now in a framework of a grid rule, which means that the judge has the flexibility of not applying it strictly. So in the table, if it says not disabled, but there's a non-exertional limitation, the adjudicator can use a framework of the rule and find that the claimant is disabled. And a quick example on that is there. And again, I'll just reference the samples on my website if you want a more extensive review. All right, post-hearing brief issues. This gets exciting because we're dealing with vocational experts. All right, so at the hearing, there's a lot of interaction between the VE and the ALJ. The ALJ's posing hypotheticals to the VE, asking if the claimant can perform past relevant work, other work, transferable skills. And so the judge is often kind of considering and deferring to the VE. However, the judge is the ultimate decision maker when it comes to past relevant work, transferable skills. And so let's talk about that, transferable skills. The way I keep it simple. Now, again, I can't fit everything in an hour. I will have some upcoming VE training on this, but for now, to keep it simple, remember that unskilled work does not create any transferable skills. So if your claimant or the claimant has unskilled past relevant work, you're not going to have transferable issues. Skilled work cannot transfer to unskilled. So by the process of elimination, the only skills that you need to really be concerned with when transferring are semi-skilled. And so in preparing, if your client, if it's that case where your client has skilled or semi-skilled that possibly could transfer to other skilled work, you want to start finding evidence that indicates that the claimant has some significant issues with being alert, because semi-skilled work requires alertness, close attention. They're often inspecting for abnormalities. They're using machinery that requires details. In CFR 20 CFR 404 1568, it goes over what semi-skilled work is. So I take a look at that. And again, just by the process of elimination, focus on semi-skilled. All right. And now, so some forewarnings, some exceptions and forewarnings at the testimony. In 2018, we started seeing an increase in remands regarding VE testimony. So it is worth your effort to really analyze when the hypotheticals given at the hearing. If you're writing for someone else, try to get that information. If you were at the hearing, keep notes, because once you get to the VE testimony, you can look at the DOT or the SEO and look and see if the RFC is consistent with the jobs that the VE testify that the claimant can perform or has transferable skills. We're seeing an increase in remands around vocational testimony. So yeah, keep educating yourself. I know it's a process. It's one that most people feel pretty intimidated about. Now, we'll say even inside the agency, it's an ongoing learning process. There's not a lot of training on that. All right, so, and I just wanted to say when it comes to AC remands, the top two reasons for remands are a mental impairment not being adequately considered and limitations. So if you have a client with mental limitations, it could be possibly an AC remand. Also new evidence. So those are the top two remands for AC briefs. And for court, it's the ALJ, depending on a CE opinion, without adequately considering it. Yeah, so take a look at that. And again, mental limitations. Both the circuit courts and AC level are remanding on not adequately considering mental. All right, so we made it to the end of the brief. This is where I usually breathe for a second, but the work is not completely done. I'll wrap this up quickly. This is editing, edit. Use technology such as Grammarly, spell check. Here you can include your client's signature or not, depending on the situation. And make sure that you've addressed any of your client's questions or concerns. And what I do, which might be the most difficult part, is set aside your draft for about an hour and then do the final edit. I've had to discipline myself to do this. It was not easy because once I'm done with the brief, I want to be done. I want to check it off my list and move on. But I assure you, if you give yourself that buffer, you come back with fresh eyes and you've put so much work into it, it's worth that last check. So that you provide your client either just great advocacy or a great work product. And then the last thing I do is provide notes to my client if I'm writing for another representative. For example, today I mentioned that although DDS said that there was past relevant work, it's not past relevant work because it wasn't performed at SGA. And I include that when I submit the brief. And I usually submit it either securely via Dropbox.
All right, well, we've got some questions in the queue. Our first question is, you mentioned the two big reasons right now for AC remand. Could you restate the second reason?
Oh, sure. So just to recap, the first, really the top two reasons for AC remands is the ALJ not adequately addressing a mental impairment and subsequent limitations. And the second reason is new evidence. So, after the ALJ hearing, there's new evidence. Submit that to the Appeals Council, and they're remanding those quite often. There may be a situation where the claimant or the representative was unable to get evidence into the record, and the AC is remanding that often as well.
All right, here's our next question. Is an AC brief always necessary?
No, it's not. That's, you have to look at all the cases on a case-by-case basis. Some claimants just do not have the impairments. Maybe there's new evidence that, appear during testimony that indicates the claimant maybe is more functional. So yeah, no, not all cases require or need an AC brief. I would evaluate those carefully. Um, but yeah, just not all of them, no.
Okay, our next question is, if medical records are voluminous, how do you go through them expeditiously?
Yeah, that's another great question, especially if you have one of those big BA cases. What I do is there's a lot of hospitalizations. I go straight to the discharge summaries because often, there's a lot of medical evidence, maybe even a cardiac issue. You have all the objective evidence in the record, but all you really need is that discharge summary. There, often the physician indicates the current functioning level, how they were discharged, what the discharge diagnoses are, and any treatment or scheduled treatment. Also, on intake assessments, particularly for mental impairments, often there's a thorough intake assessment, and then after that, it's kind of the same evidence. The progress notes indicate the medication, and unless something's come up, the evidence is the same. However, if you go to that intake assessment, you'll get a lot of good background information, what the current symptoms were when the treatment started, and medications. So that's what I would focus on: discharge summaries, intake assessments, particularly in the larger VA briefs files.
Great. Here is our next question. For pre-hearing briefs, how long do you think the brief should be on average?
Okay, so for on the records, those are typically just a couple of pages long. For pre-hearing briefs, those can vary. Extensive pre-hearing brief, I would say no more than 5 pages. After 5 pages, you're going to lose the ALJ's attention. So 5 pages at the most. I would say the average is around 3. And sometimes, depending on the relationship between you and the ALJ or the client and the ALJ may have a preference format. And so that can determine how long the brief is as well. But most often, if the ALJ has a preference, it's pretty short. It's succinct, straight to the point, what they're looking for. And most of those are, I usually get about 3 pages. It can be challenging to keep them to 2 to 3 pages, but unless it's an extensive VA file, 5 pages or less, and even 2 to 3 pages for the on the records or a short pre-hearing brief.
And I see that our time is coming to an end, so let's just do one last question.
Okay.
How important are post-hearing briefs?
I love post-hearing briefs. It's a great opportunity to address the things that you wish you would have said at the hearing. It's a great opportunity to address, let's say, testimony that either brings up another impairment or functional limitation. Also, if the ALJ kept the record open so that you could submit new evidence, excellent opportunity to just hone in on the new evidence. What I do caution is not to essentially hand in a pre-hearing brief as post-hearing. Don't address all the issues, make it succinct, focused, and it can be very effective in helping guide the ALJ and also refresh their memory since the hearing to the evidence that you find the has the most impact in getting to a favorable decision.
Well, thank you very much. This concludes our presentation today. Terri, incredibly informative and entertaining. I know we all appreciate the advice that you gave today, and I think our attendees will hopefully be avoiding some hearings in the future.
Thank you.